Hey everyone, bear with me. Just unusual gubbins back here. There we go. So, yeah, welcome this week. Hope you guys have had an all right week this week. Just pin that up there as well. Yeah, cool. Right. So, yeah. Oh gosh, here we go. I knew something. You've got to do something. Yeah, cool. So, as always, this isn't legal advice. We're doing our best here to be helpful. But we ain't going to get it right every time. And just to say as well, as always, if you could fully anonymize your question. So ask your question as a what if question, as in what if someone had been told to wait until the bailiff comes, blah, 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 rather than saying it's happened to you. You're right, Michael. That'd be awesome. Just kind of helps me out. And also just to say as well, like obviously you can put questions in the live stream if you want to, but it is going to be easy for you if you put it as a comment on any video on the channel, because I get notifications which I just go through just before the live stream, and it just means that hold a minute, someone's yeah, so it's cool. Yeah, it just basically means that you don't have a character limit, so you can ask a full question rather than like a multi-parter. In terms of a little bit gossip from me, me and Will are running a little free webinar on the 10th of June, which is basically how to trigger a homeless application, basically. So it's going to be pretty straightforward, probably like an hour and a half or so. And first bit we'll be just looking at what the law is in terms of, what does the law actually say about making a homeless application? What do you actually have to do? Then we'll look at the actual kind of, the nitty gritty of like kind of create a template letter. So people will be coming from different sectors, but the idea is everyone will come away with a working template to take it forward. And then we'll have a little section as well about just kind of the usual sorts of things councils say to try and kind of that aren't lawful. And what you can do about it basically. So that's coming up. There's like it's free, and it will go up on YouTube afterwards. I might even broadcast it live. I don't know yet. But yeah, basically, there's 5 places left. If you go on the Eventbrite page, so if you go on Eventbrite, search for homelessness best practice, you'll get you'll basically see it. And talking of which, there's still about 10 or so places left on the next homelessness law training on the 11th of July. I say 11th. Next week's one's full, but yeah. So if you're interested, its price starts at 30 quid. I've had a few sneaky people, a few sneaky professionals try and get in on the £30 ticket, and they've basically emailed in from their work email address, which I've gone back to them saying, "What are you doing?" So yeah, that's me anyway. Anyone got any other sort of news or anything that's happened this week that's worth drawing our attention to?
Um, I haven't read it yet, but there is some new statutory guidance for IDVAs, so Independent Domestic Violence Advisor guidance, and it is statutory. Um, I don't know, it sounds like a good thing to have sort of statutory guidance to strengthen sort of the consistency and support for survivors. And I know the government's also going to put out guidance on independent stalking advocates to be published sort of next year. Um, and they've updated some other bits of guidance. But yeah, it seems to be sort of like covering issues of like how to navigate like the criminal justice system, how to signpost survivors, like the different levels of support, the different, not just like emotional but practical support, sort of. Yeah, I haven't read through the guidance myself yet, but it does look quite comprehensive.
So
Um,
I've just Googled it. I've got one that went up on the 9th of May, which is Independent Domestic Violence Advisor Statutory Guidance. And then there's another one about guidance about independent advisors, which include ISVAs as well as IDVAs. So is that the same? Is that all? In fact, that's a
so I
year
th
old. Ignore that.
I
So the first
think
one
the first one, but I think the other one,
is also
there's one
useful.
has been that just like been updated.
Right.
So yeah, the ISVAs one has been updated, but the IDVA one is completely new. Um, so yeah, I don't know how useful it will be, but it's something that is potentially worth looking at. Both as like if you are going through this actually to know what to ask your IDVA for. Because actually it's quite a powerful tool if you're going through domestic abuse and you're given an IDVA, you know, I'm imagining this is quite wordy, but sort of trying to get your head round actually what it is they can do, what's the scope of their role, so they're not palming you off. So there's something there around accountability in my head. And useful for IDVAs and other professionals when you're referring into this service, just to have a bit more awareness. But yeah.
Cool. Yeah, I like IDVAs generally. I mean, they're one of the best sectors I'd find. Don't like Marek's, but that's another issue. Yeah, cool. Thanks, Shannon. Anything else from Will or Caris? If
I
not,
don't know if anyone's read it, but there was a Hackney Council special report
I saw mention of it. Yeah, yeah.
It's quite good, but I don't think I think it just scratched the surface though.
Yeah, I'll try and dig that out and put the link into the live chat because it's worth being aware of, even if you don't read it all. I'm
Yeah.
feeling quite smug about that database I've done because I had a few people ask questions about stuff, and I'm like, oh, I can find actually the LGO case that responds to that now. So it's been quite useful for me actually. But yeah, cool. Thanks, Karis. Cool. All right. As always, are you right, Martin? As always, we're going to start with the anonymized questions that came in through the week, and then we'll get onto the questions in the live chat. Then we'll finish off with I think there's one question this week that wasn't anonymized. So let me get the screen shared. Here we go. So question one, and yeah, afraid there's not a particularly positive answer to this one, but not much we can do about that. So yeah, a friend of mine is going through a relationship breakdown with a partner and is sofa surfing on the ex-partner couch. Will he be eligible for help with the council? He also has health issues with mental health and physical health with fibromyalgia. So there is some stuff the council can do. So it's always worth making a homeless application to a council. But unless there's domestic abuse involved, this is one of the things which I'm like amazed that the law is what it is, because generally I like the law. Generally, I think the law's pretty good. But where you've got a relationship breakdown where there is no domestic abuse involved, the current case law, which is actually a very old case called Moncada from the late 90s, basically states that the separated partners need, it's reasonable for them to continue to live together. I mean, I wouldn't be surprised if some point we'll see an update to that case, that position, because that is a recipe for domestic abuse if there isn't already some there. But that's the current position. So effectively, you would not be legally homeless. But that doesn't mean to say the council can't help. There may well be some application stuff to do around social housing in general, which in some councils there is a reasonable chance of actually getting something. Not so much in London. But then, I mean, again, it's always worth approaching a council because they might look at it and say you might have a good housing officer who actually basically tries to push for some kind of assistance, like say like a rent deposit scheme or something like that. But certainly on this information here, you wouldn't even get as far as priority need because they would say that you're not legally homeless. As I say, if there is domestic abuse involved, then it would be different. So in one sense, although I mean, I guess the mental and physical health issues might be relevant down the line with the banding of the housing register, but you're not going to get as far as priority need within the homeless application process because they'll say you're not homeless. That's my fear. So yeah, Shannon.
It'd have to be like really high threshold. So it would have to, but is it potential that, sort of the Lomax case law here, the impact on the health? So if the impact on the mental health and the fibromyalgia was so sort of severe and it is a high threshold and you need like psychiatrist notes and sort of consultant notes sort of explaining the evidence as to why your living situation is making the impact on your health conditions so bad and causing such a detriment, then they would sort of be they could be homeless, couldn't they? Because it would be unreasonable to continue to occupy. But like I said, that's quite a high threshold. So I just I wanted to throw maybe yeah.
Yeah, no, I think that's the argument. That's basically what you're having to. I mean, although having, I mean, I guess the other, yeah. So just to kind of follow on from Shannon's point there. So the argument you're making there is that you're homeless because it's unreasonable to continue to occupy the accommodation. So that's kind of your position. Just thinking about it off the top of my head, we don't have this detail in this question here, but let's say the accommodation was actually the ex-partners, it was their tenancy or their home or something, and they wanted you to leave, but you didn't have any rights to be there, then I guess that would be a little bit more straightforward because you would then be homeless and you could then make a homeless application. So yeah, anything to add on that one, guys? But definitely worth approaching the council. Let's say that much, and just trying to have a sensible conversation with a decent housing officer. I will.
No, I was going to make the point which you just made that if it is her place and she wants him out, ultimately, and if she does make him leave, then he's homeless. So I think that would be worth pursuing.
Yep. Cool. Okay. Question two. I don't know the answer to this one legally, so I'll leave it to the others. But yeah, what's the deal with landlords repeatedly just showing up unannounced at someone's property for no obvious reason? Now, I know that's not lawful, but I couldn't tell you why. So, anyone want to have a go at this one? I'm assuming it's like the right to peace or whatever it's called, quiet enjoyment of your property.
Yeah, quiet enjoyment. Um, I came across this recently because it happens quite a lot in temporary accommodation, where the landlords or their agents think they can just come in and even let themselves into the property, and they say we're just coming to check that you're not misbehaving. And in one case, the person that came in did so while the client wasn't there, decided that the place was a mess and reported it to Children's Services. So then, I mean, you may say, well, that was a good thing to do because it was in the children's interest, and if the place was awful, you wouldn't want children living like that. But I had to say, well, I can't. It's really difficult because I mean, if you're a tenant, then arguably they shouldn't. You've got protection from Eviction Acts and things amount to harassment. But if they would, I mean, if they were just repeatedly showing up, I mean, it depends how much repeatedly is. I mean, twice a year is sort of repeatedly, but I mean, if it's twice a day, then it is harassment, isn't it?
At what point? So, what action can you take in that situation? So, what, like, I mean, what do you go to the council and say, "I've got my landlord who's harassing me," or what's the actual defense against it?
Yeah, I mean, well, it is a criminal harassment is um, it's an offence under the Protection from Eviction Act. So you could get an injunction, or you could get a court order against them doing that. But I mean, it seems a bit extreme. And you could complain to the local authority, I guess. I mean, that's what I did, and they sort of told me to get lost and said it was perfectly within their rights to go around there. But I think they might behave themselves a bit better. And they'd also, you know, they go that extra mile of being unpleasant and start shouting at the tenant about how they're going to report her and she'll be evicted and her children will be taken into care in front of the children. So yeah, I mean, it's just a question of complaining, or if it's a sort of you're a tenant and it's happening, then think about going for a court order.
Okay, cool. Karis?
I was going to say they have to give you at least 24 hours notice to come round, with stated reasons why. And in an emergency, like this is for gas, they could say they can smell gas. Then there's a number you can ring and they come out and do tests. But they would need to have a valid reason to come around, and it should always be in writing. And it depends on where they live as well. If they live in the same building, then it's always showing up. If you have to show that they're always showing up and don't have a reason to be there for your harassment.
Are there any kind of like cases or like sort of guidance or anything like that that kind of goes into more detail about that sort of thing? Because it just seems to be, I mean, I imagine it's quite a common thing.
I can't think of any off the top of my head. There must be.
I mean, I've never, because there is a textbook called Quiet Enjoyment, I think,
Yeah.
by a few big bods, but yeah, I haven't got it. Expensive. So okay, well, hopefully there's some stuff in there which will be useful. Third question, oh, just to say to the person, someone just put a question in there in the first person. I know it seems like I'm being annoying, but I've just deleted it. If you could rephrase your question as a what if question, rather than kind of saying, you know, putting your personal data on the channel, that'd be awesome. Okay, then this third question, this is the final anonymized question from the week. It's a little bit to it, but not too bad. So person has significant care and support needs and was being supported by a family member. Family member then moved away. Care and support provided by social services not enough. So there was more detail to this. So I think they're getting like 6 hours a week or something from social through a care package. There is some evidence from social services and the doctors to back this up, as in that there's not enough care and support. The person therefore wants to move closer to the right. So I thought I'd anonymise it anyway. Who's able to provide care and support. An individual has applied under Part 6 and is Band C. What is the chance the circumstances would warrant Band A or B? And then here's the kind of criteria in a sort of summary. So the criteria for Band A, urgent medical banding, are listed in section 4.6. Just to say, guys, I don't even know which council this is about. Every council's got a different banding system, so don't assume that this will be the same for your local council. You have to search your local council's name in the words housing allocation scheme to get your own local policy. But this is the policy of the person who's asking the question. So they include the words life-threatening as an example of severity of medical need and unsuitability of current accommodation. And then secondly, Band B, high medical needs, section 4.7 lists examples of qualifying medical conditions and disabilities. the band C medical assessment for medium need is detailed in 4.8. This is like quoted from the housing officer who's kind of reported back to them. This is the level of medical need I feel is most appropriate to your circumstances, combined with an additional band C for social reasons to receive support from your aunt. So, the health issue. I mean, they did give a bit of information about the health issues. I might actually be able to find out what they said, because it might just be useful to kind of give an idea what sort of health issues we're talking about. If you just bear with me a second, but basically, I have my suspicion is that the council is probably within their rights to say that this is medium. This is medium kind of need, because when they're talking about life threatening, they're talking about, you know, people with terminal illness or kind of, you know, very, very, very serious conditions. Whereas I think, if I'm just trying to find the, oh, I hate Facebook. I've got to try and navigate it. Bear with me. So yeah, so what we got, health issues include ADHD, Tourette's, I think autism as well somewhere. Yeah, autism. So I think that's kind of led to the care and support needs assessment and kind of the eligible care and support needs. Let me just explain what that means. Actually, it's pretty useful to say. So care and support needs is not a term which is very well defined within the Care Act, Care Act 2014. But there are these kind of so-called eligible care and support needs where someone is deemed to, you know, require 2 or more from a list of things, like a list of support. And if you qualify for that, then that means adult social care will owe you some kind of duty to support you. Doesn't necessarily mean that that would amount to much in a lot of circumstances, but that's what it's talking about. So yeah, so I would say that that certainly on the evidence that came in with the question, that this would not qualify for band A or B. That would be my feeling. Obviously, there might be more to it that I'm not aware of. And so actually, I don't see how this could be challenged really, unless there was more information, as I say, more severe health issues. Because yeah, obviously those are, you know, they always qualify for care and support, so there's significant issues, but that doesn't mean to say that they kind of hit that level of urgent medical need or high medical need. I would probably argue that what would need to happen here is you need to go back to adult services and basically say, look, you know, the care and support is now changed because the relatives moved away. You know, what can social services do? I don't know that this is going to result. Yeah, I don't think you could really challenge that banding. Really, that would be my guess. Do you guys want to say anything about this?
No, not really. I think you
Okay.
covered it.
Cool. Hey, right, cheese face, right, Tiff. You're right, Martin. I think I said hello to Martin already, but hello again if I didn't. So right, let's get into the live chat. If you're watching, as always, if you want to give it a like and a whatever, share or something. Let me just piece this together. It's a multi-parter, so hold on. Right, 2 more bits. Cool. So I'm seeking advice regarding a family who were previously ranked among the highest on the housing register due to having an active homeless application and being in an overcrowded situation. Unfortunately, the council wrongly closed their homeless application, which caused them to lose their priority status. Following a review, the application has now been reopened. However, for nearly 2 months, the housing register team has not updated their status or restored their original banding, despite providing all necessary documentation, making numerous phone calls, submitting formal complaints, blah, blah, blah. There have been no progress. As a result, the family is missing out on housing opportunities they would otherwise qualify for. To make matters worse, the landlord has already begun the eviction. Okay, so speaking of my database of LG SCO decisions, I might have to just wait a minute, but I've got some decisions which are very similar to that. And essentially the answer from the LG SCO decisions would say, keep going down the complaints process. So I didn't say what stage this is at, but let's say it's at stage 1. Keep going to stage 2. Don't be like disheartened if the stage 1 isn't upheld. That's very normal. But one of the many things the LGSCO can do when you get to that point is that they can get the council to reinstate the banding. Now, I appreciate there's this kind of time sensitive thing where the eviction's kind of in progress already. other than kind of complaining loudly about it involving councillors and stuff like that, I don't know that yeah, I don't know that you can do much else that's going to help in the short term. But obviously, this is very much in the council's interest to correctly ban this family to maximise the chance of them getting housed before the eviction happens, because I'm guessing here that we're talking about someone who's going to be in priority needs should they become homeless. So that's my answer, is to basically just rush through the complaints process as soon as possible. Talk to your local councillor, talk to your local MP, and basically plead with them to chase up the housing team to reinstate your banning. Interestingly, one of the things the LGSCO often do is they'll ask the council, had the family been correctly banded when they should have been banded, would they have had an offer of housing? And if the answer is yes, then there is significantly more compensation available that will be recommended. Obviously, sometimes, I mean, I don't know how much this person is able to know about the current pecking order of the banding at the moment. So it may not be possible to know actually whether you would have, whether they would have actually got housed already, but it's entirely possible. It just depends on the council, really. So that's my answer. Have you guys got anything to add to that at all?
A little bit, if I may. What this case highlights to me is well, a couple of things. One is it's unusual for a family to get higher status because they've got an active homeless application. A lot of allocation schemes are designed to sort of keep people with homeless applications lower down so that they're not swamping the whole queuing system, which is what was happening sort of 20 years ago. But assuming that's right here, that's good news. But it raises the question of when should you make a complaint and when should you take legal action? Because certainly taking legal action is going to be a lot quicker, because you can just threaten, you can send a 2-week judicial review pre-action letter, and then you can go for a legal aid certificate and issue judicial review proceedings if you can make a case to show that the family are suffering as a result of this, which it would seem like they are if they were on the highest ranking and they're homeless and they're overcrowded. Then you could bring a judicial review to say they're supposed to run an allocation scheme, they're not doing it, and they need to basically get a court order saying what they should do. So you could do that. The danger is that they may say, well, we'll offer you accommodation, but it's not going to be social housing, which they could probably get away with doing, even though they were in the high band before. So that's the danger as well. Well, I suppose that's a problem with complaining too, isn't it? Because, but the danger is if you don't complain, then nothing happens at all. So think about, I mean, how long do you think, Mike, it would take, or Shannon or Karis, for an ombudsman complaint to reach fruition in this type of situation, or to get some redress? Because we're talking months, aren't we?
Yeah, definitely months. Let's assume that this has already gone to the first stage and there's been a response. Stage 2 is going to take a month or two, and then LGO, I don't know what the current kind of backlog is, but generally, I mean, certainly when I've dealt with them, it's like 3 months sort of thing before they even start investigating, and then the investigation might take like 1 or 2 months. So it's not quick. I guess the reason I say that is because in some councils, the fact is, people don't get housed that quickly on the housing register. It obviously depends on the council. So I think that's probably one thing to add to this, is just to do some digging around on the council's website and consider making an FOI to find out what the average waiting times are. I was reading it, this is like a bit of a long story. I did a video at the beginning of the year, which was like average waiting times for people owed domain duty. And when I did the FOIs, I did get a few officers getting snooty with me saying, this is wasting our time. But legally, they have to make that stuff available. So it shouldn't have to make an FOI to find out what the average waiting times are. There's a bunch of councils in Essex who actually were really good on this, where if you go on the council's website, they've kind of got really like up-to-date live kind of waiting times and expected waiting times, that sort of thing, which I think is a really good model. But most councils don't. They kind of don't tell anyone. But I think that's something to add in. But maybe it's a case of kind of just, as Will says, there's potentially a problem of complaining that you might just end up getting given private rented accommodation, in which case maybe just try and be as polite as possible, keep chasing, and maybe involve the councillors and the MP. That might be a more sensible way of doing it. It does depend on your councillor and MP if they're decent or not, but certainly in Bedford we've got some decent ones out there who will go and pursue it. They will chase the council team up and actually get them to respond when they should do. So in terms of what you're suggesting, they will. Presumably, they need a solicitor to do that. That's not something which sort of a layperson is going to realistically be able to do in terms of.
No, unfortunately, you would need a solicitor to take those steps and towards judicial review proceedings. One other thing I'd say is I noticed that they said they made complaints via email. I mean, sometimes when I've made complaints via email, I find that if I go to the website of the council and I go to their complaints page, there's a form to fill in or a portal, and you can make a complaint that way, which sometimes gets through to somebody else who deals with the complaints in a way that emails don't. But it varies from council to council. So you might want to try doing it via the website.
Yeah, I mean, I try to avoid that wherever possible, just because I don't know where that goes.
Yeah,
But yeah,
yeah.
I just another snooty response the other day because I made a homeless application via email rather than using the portal, and they came back saying basically, what are you doing that sort of thing, and I was like, well, because it's the legal way of doing it, really. So yeah, how you right, Shadnet? You right, BYRE? So next question. Hopefully that was an adequate answer. So multi-part. Let's just get this all together. So a person requested review under section 202 because of mobility issues and unsuitable accommodation. The extension was agreed with the council, but they didn't get a reply at all. The solicitor confirmed that the council missed deadline and will submit an appeal to county court. Will the council settle, offer accommodation and try to avoid a court case? The person has strong medical evidence, mobility problems, and there's been some abusive behaviour at the current accommodation. Do you think the council might settle the court case? Thank you. I don't. Well, my guess is yes, but again, I'll leave it to the solicitors here to kind of maybe give a bit more of an answer about that. I mean, councils don't want to get that. It's expensive to go to court and lose. So unless they think they've got a smashing case, I would imagine that they don't like defending stuff. They just rather just settle it. But yeah, as I say, Will or Karis, I don't know if you want to give your 2 pence on that because you know better than I do.
Do you want to say anything, Karis? I've got a bit to say, but I don't want to barge in every time.
Go for it.
Okay. Well, with a homelessness case, well, with a lot of cases, local authorities are really, really bad at processing the information and actually making decisions. And why by that I mean a decision to settle or make an offer or something, because it's much easier just to leave the file closed until the last minute, and then you get a barrister or somebody to go to court the next day. And it's only at that point that somebody looks at it and says, hang on a minute, what's happening? So, because I've got, it keeps happening, particularly with disrepair cases or possession cases, where the solicitors try and get instructions from the housing department for weeks or months. And then the day, like 3 days before the hearing, I'll get a message saying, oh, do you want to settle this? And I had one the other week that was going to go to court, but then we adjourned it. And of course, the council have gone back to sleep now, so I'm not the solicitor can't get hold of anybody. So the reason I say that is it's the council should make I mean, if you've got a strong case, the council should try and settle it. But probably they won't do it because it's easier just to go on fighting it. And the stage at which they might settle it is where they have to instruct a barrister to prepare a skeleton argument in the homelessness appeal stage at a sort of early-ish stage in the proceedings. And at that point, the barrister may do the skeleton argument and say to them, well, hang on, you ought to settle this. But it's quite common even for the barristers not to play that role in a homelessness case because I mean, no disrespect. Well, there is disrespect, but I'm sure barristers and housing local authority people recognize this. But there's an incentive really for barristers to go on and fight the thing, even if it's hopeless. Number one being they get paid. Number two, if they manage to win a rubbish case, then they can put it on their CV and the council will come back to them. So unfortunately, councils don't tend to settle homelessness cases very much. They do, for some reason, tend to settle possession cases quite a lot. But so I don't think they will try and I mean, if I had to put money on it, I'd say they probably go all the way to trial.
And again, like how long's a piece of string, but like what's the sort of typical time span on that kind of thing? Let's say London courts. I'm
Yeah, I
assuming
mean,
we're talking months.
I got one. I issued one in January, February, or March, maybe. I forgot. A little while ago, I issued one, and I got a hearing date for October, November. You know, it's 6 months from the. It takes them about a month, 2 months to issue the thing and give you a notice of hearing, and that can be 6 months away. So, and I kid you not, nobody at the council is likely to look at the case once they've done the initial skeleton until 2 weeks before the hearing. So I'm afraid it's likely to drag on all that time. So you might want to go for an interim application regarding temporary accommodation if that's necessary, because that could speed things up. But that
And is that because the council's then paying for something, so they're motivated to actually sort it out?
well, also if I wanted temporary accommodation during that 6 months and the council refused to give it, I can go to court and make an urgent application and say, hang on, I can't, you can't expect me to wait 6 months. And so you get a sort of mini trial at that stage. Because if the judge says, yeah, this is a strong case, I'm going to make an order requiring the council to house you, then it's likely they might just drop the whole thing. But again, don't underestimate their thick skin, and they may just go on. Because there's the other thing that the housing officers can often take this quite personally, especially reviewing officers who tend to have quite high opinions of themselves. And you know, I'm not going to give in to this sort of thing. So unfortunately, the pressure is all against settlement.
Yeah. Well, that's interesting, although it's another depressing answer. Cool. Thanks very much. Next, well, it's more of a point where I think this kind of follows on from the discussion we're having about landlords just turning up somewhere. So this is someone saying, reviewed one local authority standard temporary accommodation agreement this week, which stated officers had unrestricted access to the property at all times without notice to ensure occupancy in absence over 24 hours needed local absence over 24 hours needed local authority approval. So yeah, so if you want to go away for a day to see family or something, you've got to get approval before you go. I would imagine with like interim and temporary accommodation, there is a level they can do what they want. I don't know. I don't think to contrary of that. So yeah, doesn't surprise me. I would have thought that's probably quite common actually. I think the question we've dealt with earlier was probably more talking about like an assured short hold tenancy, where it's kind of more long term stuff really. But yeah, thanks, Martin.
Sounds well.
Oh, say again. Sorry.
It sounds well trauma informed. Like
Yeah.
someone's TA and then someone can come in at any time without notice. Like that would shit me up. It would shit anyone up, right? Like excuse the language, but like if someone
Yeah.
just walked into your home unannounced or whatever, like I understand it's TA and I understand that they don't want people getting TA when there's no like need for it or whatever. But the stats on that is ridiculous anyway. I don't know. I'm this is not a
Yeah.
legal answer.
You just
Sorry. It was
imagine coming out of the shower, couldn't you? They're like, "What are you doing?" Like, "Well, we knocked," and yeah, didn't answer. Yeah,
You know
That
what I
happened
mean?
to one of my clients the other day. The landlord and a man that they brought round let themselves in while the client was in the bath.
I'd be like barricading myself in.
Yeah.
But remember, the
And they come
danger
around with
is, sorry,
locksmiths.
Karis.
Sorry.
Yeah,
They
yeah,
come around with locksmiths as well.
I'd be deadbolting it. But anyway,
Yeah.
probably that's not legal advice, but just to make that clear. That's what I do anyway. So yeah, right, cool. Next question, which is a more benefits question. So, what's going on here? So I'm not quite sure how much we can say about this. So vulnerable person put on DWP complex team referral has requested all phone calls and information within 7 days. How long do they get to provide that? So if we're talking about a subject access request, you can make a subject access request however you want. So whenever you first spoke to him, or when I mean, ideally you want to put it in an email, really. But the law says 30 days normally, and if there's kind of particular complexity, then they can get up to 3 months. Although I've only seen that once, so that's not very likely. So that's probably. But in terms of when we talk about phone calls, I don't have an answer about whether recording of phone calls is something which is accessible because I don't know how long organisations hold them for. So although you make a call, it says this call might be recorded for training and monitoring purposes. First of all, that doesn't mean it definitely is, and secondly, I don't know how long they actually keep the recording. So I've never seen audio come back with a subject access request, but that might just be because I never thought to ask really and didn't think to chase either. So Yeah. Cool. Next one. Oh, I hate Times Roman. Get me back to normal. There we go. Don't know why I did that. So what would you say to someone for someone getting ready to go to take a case to judicial review on a pro se? What's the anyone knows what that means? Is that Latin or something?
Yeah. I think
Feel free to ask more about this hypothetical. Will, do you know what that means? Oh, there's a bit
pro
more
se,
actually,
I think
sorry.
it means do it yourself. I mean, let me just check. I'll Google it. I think it means doing it yourself. So here we go. Pro se is the Latin term for oneself or on one's own behalf. In legal context, it refers to a party in a lawsuit who represents themselves in court without the assistance of a lawyer. So that's what it means. And
So in terms of like what would you say? I mean, I think what we'd say is uh yeah, get a solicitor if you can. I know it's easy for us to say that, but it's just that seems to me be something which is quite difficult if you've not done it before.
this something I've been thinking about quite a lot lately, especially listening to that this book about the family courts that I've been listening to, which is that the court service ought to provide a service that enables members of the public to obtain redress without lawyers. I know that may sound naive and crazy, but it's especially true if you recognize that most people can't afford lawyers, and nowadays they can't get lawyers because of legal aid cuts. So the starting point is I wouldn't advise anyone to think that they could pursue a judicial review against a legally represented opponent, because you're just going to, it's like trying to fix your own car or do your own dentistry. I mean, you're just going to fall down on the technicals. But if you did it in such a way as to say, I'm making this application, um, I'd like to make it clear I have very little understanding of the law on this, and I'd like the court to adjourn the proceedings or give directions or do something to let me have access to justice, because it's absurd that I should be left, fighting against, especially against a legally represented opponent who's funded by the government and by the taxpayer. So really, there ought to be a standard set of directions that people ought to be putting in, I think, saying, please recognize that I'm disadvantaged here, and direct. I mean, you could make a direction that the other side should try and find you a solicitor. I mean, it may sound naive, but if, say, for instance, if you've got a mental health problem and you've got no capacity, the court simply cannot go on without you having a litigation friend appointed. Now, it's not too big a leap in terms of justice and common sense to say the court shouldn't make any, in a judicial review, which is literally like Lewis Carroll sort of through the looking glass to most people, the court should recognize that a non-legally represented and legally trained person is a vulnerable person and should be protected by the court in the same way that somebody who has mental health problems is. But I guess it'll be in a couple of generations, people might look back at this in the same way as kids being sent up chimneys and say, wasn't it crazy that they allowed this to happen, that you'd go to try and challenge a decision and the council would have a lawyer paid by the taxpayer and you'd be left wondering what the hell they were even, trying to understand what they were even talking about. But sorry, that's the
No, that's all helpful.
long
So
answer.
I mean, so Martin's just put a comment in there saying, so had this argument with the duty clerk at the High Court on Easter Sunday, as they wouldn't accept application from an individual who was not legally trained despite information submitted being identical. And then a bit more, so joke of it was that they were denying someone access to redress justice and the application was urgent, understood and went to check, but came back and refused again. So, I mean,
Well,
yeah,
that's even worse, yeah.
yeah.
And I'm not saying they were wrong to do that, but it just shows how the whole legal system is not fit for purpose. If everybody could easily access a lawyer, then I can understand it's in the court's interest to have lawyers, because if you've got a litigant in person, the judge has to sort of become a sort of advisor to explain the law in great detail. Whereas if there's lawyers, they can assume everyone knows what they can go on chatting away in legalese.
So going back to the question, it's kind of saying that they've already sent the pre-action protocols, which says that they've obviously kind of know something about all this. They've done some research here in terms of what can be done.
This
But
is
yeah,
concerning because they said both councils.
as okay. So what, as in, I mean, that could be a number of situations. It could be local authority referral. It could be just making an application to two councils and getting messed around by both. Yeah, and then yeah, sorry, there's a bit more just reminding there saying at the end they got a solicitor to obtain the relevant paperwork, submitted exactly the same thing again and got accepted. Yeah, so I mean, yeah, we add it to the long list of things that this country needs to sort out really, but ultimately won't happen until members of the public do so. So as in, it's good to kind of talk about it here. And if people who are homeless at the moment can get through it and come out the other side all right, then getting down to your local MP and your local councillor and telling them what's happened is probably not actually a complete waste of time. Because I'd imagine most people actually in elected positions have no idea about any of this whatsoever, and so don't know to push for it. As an aside, I saw an interesting thing come up with because they're talking about abolishing the two-child benefit limit thing. And there's a guy called Joe Hailwood who's like very knowledgeable about housing benefit and benefits, and he basically said it's going to have a massively negative effect on the benefit cap, or people who are subject to the benefit cap, because it basically messes around their housing benefit and UC entitlements. But yeah, so if you he runs a blog. I forgot what the blog's called, but if you Google Joe Hailwood benefits, he'll come up. So there's some interesting stuff about that. So right, there's some questions about benefits again, which again, I don't want to jump into. Does anyone know what a Section 83 is? That a housing thing or is that a benefits thing? I've never heard of it. Or you're on mute, Will, if you're talking. Will, you're on mute. Will, you're still on mute. Say that again, Will. You're on mute.
Sorry, do you know which section which
so
act you're talking about?
Yeah, which act? Well, yes. Yeah, so talking about housing benefit isn't housing benefit supposed to pay rent still? Section 83 issued due to rent. How can that be paid? Is that maybe a Section 8? No, it seems to be Section 83. Anyone got any idea what the context is there at all? That doesn't ring any bells at all.
Sorry, it's proceeding or possession. Something to do with possession, the 83 of the Housing Act?
Yes.
No?
It is. I've just looked at it. It says Section 83 of the Housing Act 1985 deals with the possession of a secure tenancy. So that may be what.
Okay, well, so if it's a housing question, let's put it in. Hold on.
So it may not be that act.
Well, that would make sense, wouldn't it? So,
oh. That doesn't sound. I can't see the whole.
So yeah, there's a bit more to it. Hold on. Cool. So yeah, I mean, so some vulnerable people are allowed to stay on legacy benefits and vulnerable person on DWP complex team referral requested to do so. They stopped disability part of ESA, then stopped all money. DWP instructed housing benefit to be stopped. No income, so the housing isn't housing benefit supposed to pay rent still? Section 83 issued due to rent. How can that rent be paid? All of that is after unlawful harassments and retaliatory harassment to a vulnerable person. Can that be tied into the Section 83 case? How can the person get Section 83 stopped? Any grants to cover the rent? As I say, I've got absolutely no idea whatsoever. So, yeah, if any of you guys know more than me, then feel free to put something in there. So Will looks like he's reading something. So what I'll do is I'm going to come back to this question if we get anything. So let's go to the next one and then come back to this one. I think there's an easier one here which we can answer, which is nice. So if someone is in prevention duty, once it's finished, then relief duty starts, if I'm right. Does the council then offer emergency or temporary accommodation? Can someone advise, please? So and there's a bit more to it as well. So the prevention duty doesn't automatically turn into the relief duty unless the person becomes homeless. And so, and yeah, I've whinged about the prevention and relief duties plenty before, but basically the prevention duty can keep rolling on indefinitely, or the council can stop it. It just depends what they want to do, really. So yeah, but if the person is in prevention, then they become homeless, as in the Section 21 expires, or they actually become properly homeless, then that would immediately turn into the relief duty. So, and at that point, if there is reason to believe that you might be homeless, might be eligible, might be in priority need, let me go back a step. It is probably worth just explaining the pedanticness about this. So the prevention duty is triggered when the council is satisfied, as in they are sure or fairly sure that you are in fact threatened with homelessness and you are in fact eligible for assistance. Now, if you then become homeless, presumably the council shouldn't have to try very hard to be satisfied, as in be sure that you are homeless and you are eligible. That's when the relief duty starts. However, technically speaking, before that duty is or that duty is or that threshold's met, it would be possible for there to be reason to believe that you might be homeless, you might be eligible, and you might have a priority needs. And that is when the emergency accommodation duty, the Section 188 duty, would kick in. So talk here about someone having kids. So that would definitely be reason to believe that they might be in priority need. So yes, so it's basically, I mean, so technically it's not when the relief duty starts, because there could be a gap between the emergency accommodation duty being triggered and then the relief duty started. Although in this situation it should probably happen at pretty much the same time, as in probably the same hour. So that's I think answer the first part of the question. Can someone advise, please? Also, can you refuse B&B offer as emergency if you have kids and it's 1 hour away where you live at the moment? You can always refuse it, but it's not in any way sensible to do so. The emergency accommodation, so Section 108, all accommodation has to be suitable, but basically short-term emergency accommodation doesn't have to be as nice, if that makes sense, or as good. So the council could do that over the weekend if there's nothing else, for example, completely legally, and then try and move you back. What's probably more likely is they are just literally going to leave that person or that family in the B&B an hour away. And that can be challenged, but it's very difficult to be challenged without a solicitor, because effectively, and you can do it through the complaints process, but then by the time it's sorted, then it's probably too late. But certainly what the council would have to show is that they have properly assessed the needs of every single household member in terms of location of accommodation. They would also have to show that they genuinely could not find accommodation closer, which is very interesting in London, because some councils seem to be able to find accommodation in their district without much problem, and other councils have to house you 3 hours away. They'd also have to look at kind of impacts on school, if the kids are of school age, that sort of thing. So there needs to be quite a lot of homework the council would need to do to kind of make sure that offer is deemed to be suitable. But as I say, without a solicitor, it's actually quite difficult to challenge it. So that's my answer. And I guess just to say, we therefore would highly recommend that you accept any offer of accommodation you're given, because if you turn it down, then the council can end the interim accommodation duty. They might even do it unlawfully, but there's not much you can do about that immediately in most cases. So you just want to accept it and then have the argument about the accommodation being unsuitable. That's the kind of textbook answer. But yeah, so it can. But yeah, other than that, is to try and get a solicitor and try and get the suitability challenged through judicial review. Because you can't, just to say, you can't challenge the suitability of emergency accommodation through the review process yourself. You can challenge the suitability of temporary accommodation as an accommodation you get after the final decision has been made, but you can't challenge Section 188 through that process. So yeah, anyone else want to add to that at all? No, cool. And did we have anything more to say about the previous question about Section 83? Did anyone find anything out about that at all? Any clues?
Yeah, I did have a think about that one. I didn't do any reading, as it were, but if I understand the question correctly, what's going on here is that somebody's facing possession proceedings due to rent arrears, which have accrued due to benefits problems. In particular, housing benefit has been stopped on the advice of the DWP. Sorry, it may be that the housing, I don't know, they wouldn't be able to instruct the non-payment of HB. They'd presumably be able to notify the local authority that they didn't think the person was available, because they're two different organisations. So here's what I'm thinking. If it's Section 83 of the Housing Act 1985, that is to do with secure tenancies of local authorities. So you're probably dealing with a local authority landlord there. So you could put in a defence to say that the rent arrears have arisen due to benefits problems, which sound to be beyond the control of the person concerned, and possibly this could amount to disability discrimination, in the sense that it sounds like the person may have been getting benefits in relation to a medical condition amounting to a disability. And if that stopped, it could be that possession was arising taken because of something arising out of a disability. And there's two other things I'd add. One is you could ask the local authority to, and I'm assuming it is a local authority. Oh, sorry, is there more?
There's just a bit more coming in, but I don't think it changes what you're saying, Will. So keep
Okay.
going.
So the local authority are the landlords, but they are also the local housing authority for homeless purposes. So what you could do is ask them to accept a prevention duty on the basis, and it doesn't have to be that you're imminently facing homelessness. They've got a discretion to exercise at any time, and say, look, the problem I've got is that I'm facing eviction because of rent arrears. Can you, as part of the actions to be taken to assist me in avoiding the loss of my home, can you liaise with the DWP and the Housing Benefit Department, because this is I'm out of my depth. And you could ask them if they could make a discretionary housing payment to cover the rent arrears. I've had that before, where they can pay thousands of pounds. Because if the housing benefit's up and running again, which it could be if with the help of local authority, then they could do that. So I would say that there is stuff that could be done. And also the bottom line is that with most local authority grounds for possession, the court has to be satisfied that it's reasonable to make a possession order before making one. And so if you tell the judge something along the lines of what's in this question, the judge would probably say, well, I'm not satisfied it's reasonable. It's not this person's fault. I'm going to adjourn this, and I'm also going to direct perhaps the local authority to give evidence as to what the hell's going on with the benefits claim, in as much as it involves the Housing Benefit Department. Sorry if that's a bit of a stream of consciousness, but
No, I was only listening with one ear, but that seemed to make sense to me.
good.
Just going back to question 8, there's a bit more on this one as well. So there's a full stop there, I think, to make sense of it. So the individual already anticipated this would go to this way and made sure the case was rather ironclad. So what do the representation do in a judicial review? So this is going back to the question of representing yourself, basically. So so again, I mean, I'll let other people answer this, but my guess is the part of the representation is to try and convey the argument as best you can of what your position is, and I hope that the judge is going to be sympathetic and got a listening ear, really. So again, yeah, that's certainly what I think is part of the answer. Do you guys want to add anything to that at all?
I can't see the question. Am I being?
So it's sorry, it's just added here. So it's this bit here. So this is So they've already sent the pre-action protocol to both councils. And they're looking to represent themselves in the case. We obviously kind of talked about this in terms of how difficult that can actually be in reality. But I guess that kind of question of, okay, so when you get in front of a judge, what are you trying to do? Well, presumably you're trying your best to explain what the situation is and explain why it is, you're right and the council's wrong.
Well, you've got
Yeah, sorry, Karis.
so a judicial review basis is that the decision was either unlawful, procedurally unfair, or irrational. So that's kind of what you've got to put across, not just the evidence of the case, but the point of law that the decision was made. So you're arguing against the decision the council made in your case, if that makes sense. So it's all the facts you think are relevant and ironclad, is all the bits you've gathered, but they're kind of facts. And what you're talking on the point of law is that decision that was made, to stripping down to that like conclusion. Was it irrational, procedurally unfairly made, or was it irrational that they made the decision? That's what you've got to kind of focus it on.
Cool.
And putting representations in your case, like medical evidence and stuff like that, you've kind of got to put it on those 3 points. That makes sense.
Would you not say, Karis, that you could almost guarantee, though, that if you do go ahead and represent yourself in a judicial review, you're going to fail? Because all of those terms you mentioned, and I agree with what you said, but each of them is a little sort of diving board or stepping stone to a whole world of headaches and misery, defining what is irrationality and you know that you're going to be up against somebody. It's like going into the boxing ring against somebody that's trained and a lot bigger than you.
Yeah.
So the best thing you can do in representing, if you do issue it yourself, and good luck to you. I mean, I'd be delighted if you manage to do it yourself, and I hope you get it widely reported. But just ask for an adjournment so you can get legal representation, because you're going to end up coming out of court with your head spinning and having lost, and also at risk of paying a lot of costs. So it's not a good idea.
Cool. Thanks, guys. I mean, I just to ask, I guess the question is, in terms of Virgo solicitors right now, how close to capacity are you at? And can you take on a case where someone's already issued the pre-action protocol? Does that make it difficult to then take it forward?
How are you with capacity, Karis?
Kind of on the cusp, but
Well, I could.
we could.
I could take that on if the person wanted to. If they've done, I mean, I can't say that I could guarantee that it would succeed, but I mean, also, I mean, the problem is if you're not eligible for legal aid. I got asked the other day to help somebody who wasn't eligible for legal aid to do a judicial review, and there's just no way I would recommend that, because you're looking at tens of thousands of pounds just for your costs, and you're also looking at being at risk of paying the same thing for the council's costs. But if you can get legal aid, then go for it. Could I just say one thing? That last question, who said, why do they all say they haven't got capacity when we say that we want action against the landlord is the local authority? Do you see that bit?
No, whereabouts?
It was the bit that was
yeah, I got
tacked
it.
on
Yeah,
at the end of the question about the benefits and the it said,
I
why
got
do
it.
they say they won't? There we go. Yeah, I mean, as a solicitor, I think it's the other way round with my experience, that most solicitors would jump at the chance of fighting a local authority rather than a private landlord, because a local authority is good for the money if you recover costs at the end of the case. Whereas if it's just some landlord with one property and it's heavily mortgaged, and they're not sort of millionaire, then you're never going to get any money. You're never going to get the money off them. So most solicitors would be reluctant to take on that case. Whereas local authority, one thing they're good at is when they lose, which they often do, you get a check. I got one today from a council for £10,000, for a case which they should have settled early on. But it was complicated. But we will normally take cases against local authorities for sure.
So I think it sounds like this person. So I think that to the person we're talking about here, if you look at the once this, it's weird. Once this YouTube video becomes a recording, so right now it's live, but then it becomes a recording. At the top of the description, there will be a link to basically approach Virgo solicitors. And that's basically just, if you fill that form in ASAP, because it's, as I say, it may well be that if Will's the one with capacity, then we'll be able to potentially at least give you like an assessment of what's going on, if nothing else. So I think kind of go with that. So I've just to say, guys, I put no further questions from that point, because we're getting on to 8:30. There's still a few questions we need to cover. So I think, unless I've missed one, this is the next question, question 11. Husband and wife live together in a council house. The man is getting abused. He hasn't any evidence to the council. Will they put him anywhere, or will it be a hostel? So basically, in this situation, the man wants to make a homes application in writing. So there's a video on the channel called The Best Way to Make a Homes Application. I'd highly recommend you follow the steps in that. Although they're quite laborious, it does make things much more likely to be effective. Now, again, evidential threshold of domestic abuse within a homeless application process is low. The LGSCO has made it clear that the council's default position should be to believe people who disclose they've been abused. So you don't need police evidence. You don't need any other evidence, quite frankly. But having said that, in the real world, the more evidence you have, the better. So if there is some kind of evidence, it might not be police evidence, but it might be like text messages or whatever it might be. So the threshold's low. The council would almost certainly have a duty to house you whilst to make inquiries. the question about will they put them anywhere and will it be hostel? So hostel is an imprecise term. So in London, hostel is often kind of like temporary accommodation, whereas in other parts of the country it'd be supported accommodation, which technically aren't the same thing. So, and I'm not trying to be pedantic now, I'm just going to say that actually the hostel, so hostel would be kind of shared accommodation, effectively, you know, have your own room, but you kind of share bathroom and kitchen facilities. And the answer is it could be, particularly if it's in London, it's more likely it'll be hostel type accommodation. In terms of will it be anywhere, it needs to be somewhere that's safe, which depends on the risk. I guess just to make this point as well, that someone who is subject to domestic abuse in their own home can approach any council in the country effectively. Now, there's some videos on the YouTube channel about that, because there is a very weird and obscure caveat to say that, so it's not 100% true most of the time, but it's true like 99% of the time. So ordinary kind of advice to someone who is looking to approach a council because they're subject to abuse is to work out which council you actually want to approach, and that will be a question of, you know, where's safe, where do you want to be, average waiting time. So again, check out the video from earlier this year, because which council you approach will have a massive impact on how long you have to wait to get housed. And once you work out which council you want to approach, then you again trigger the homes application in writing. But I guarantee, almost guarantee that any council you approach will be saying things like, well, there's no evidence, there's not enough evidence, you know, the police haven't been told. That's not lawful. So definitely write a complaint about that. If you go onto the sorry, I'm going to have to go slight tangent here. I put out a video earlier this week about the database of LGSEO decisions. There's a link on that video in the description, which takes you to Will Flack's website, which then has this database. If you search for the term domestic abuse, you will see a number of cases crop up, and you'll see the case summaries. That is as good a place as any to understand what kind of issues crop up with the local authority and kind of how to anticipate them. So and again, I would highly recommend you approach domestic abuse services, any you've got locally, because again, they're going to help. Even if they don't kind of know housing law particularly well, they will be helpful. They will help you out emotionally anyway. They will gather evidence. In doing that, they might well consider doing a dash form or something to get a referral through to the MARAC, which again, sorry to use so many acronyms. A dash form is a domestic abuse and stalking, domestic abuse, stalking and harassment assessment form. It's like a question. It's like a set of like 28 or 29 questions, and if you hit a certain score, loosely speaking, they'll then refer you to the multi-agency risk assessment conference, which will then result in you getting an IDVA, just to kind of give us a trilogy of acronyms. So an IDVA is an independent domestic violence advisor. That is all going to be helpful for this person, basically, because very, very common indeed for people to approach a council who are at risk of abuse, and the council does not take it seriously, and they'll say things like, without a police crime reference number, we won't investigate or anything. That's not lawful, but it's very normal, very common. So you just need to anticipate that, really. But I think that's the start of an answer there. So I think, just kind of I think I'm hoping within that you've got some idea of what you need to do next. Next question 12. 2 adults, only one is working part-time, received a letter from private landlord to terminate tenancy by August. What advice would you give the situation? Okay, so if you've had a notice from the landlord, first thing to do is trigger a homeless application to your local council and include a copy of the letter, because it can't just be a letter, it needs to be a particular form. There are particular requirements. The date needs to be correct, the names, things like that have to be correct, really. There needs to be other things like gas safety certificate, stuff like that. So obviously there is an impending change in legislation where no fault evictions are going to be abolished or something like it. So I would imagine lots of landlords out there are kind of panicking and just evicting people, but lots of private landlords don't know how to do it legally. That's why you take it to the council. That's why you make a homeless application to the council with the relevant documentation, because they'll look at it when they get around to it, and they can tell you whether it's valid or not, because lots of the time it won't be. So that's what they need to do. They need to go to the local authority, trigger a homeless application. If you go on this channel, the best way to make a homeless application, check out that video, follow those steps. That's going to put you in the strongest position here to basically get forward. Now, by the sound of, or certainly based on this information, there's no evidence here of priority need. So that will limit the help councils have to give you. So really, you want to make sure that the notice has been checked for being valid, because if it's not valid, then that might kind of buy enough time to get through to this new sets of law or whatever, and kind of you can remain there longer. So that's my answer. Anyone got anything to add to that at all? If not,
I was going to say, shelter do a quick stop video, and it's actually really good. Right, if it is in section 21.
yeah. So the person just said it is valid. So yeah, still same answer is to make a homeless application, because even if you're not in priority need, there is still some help and advice the council have to give you, which will be a start. And yeah, it may not be terribly helpful, but it is better than nothing. They will be able to also provide you with kind of like other sort of contacts and stuff to look at other housing options. So yeah, let me see if I can put this link into the live stream. No, it's not. So yeah, I've just put a comment in there. If you just Google that term, you'll get the document that Karis is referring to. So yeah, I think that's it. Don't think I've missed anything. I think that covers it. There was a question about kind of no win, no fee. My guess the answer to that question is not really. Yeah, I don't know. Might be wrong about that. Will or Karis tell me if I'm wrong? Can people in that situation get a no win, no fee solicitor for housing law cases? My guess is not.
It's difficult. I mean, if it was a really strong case, then you could do. I mean, the solicitor might be prepared to take it on as a no win, no fee. But usually it's difficult to know at the beginning. No win, no fee is popular in like disrepair cases and stuff, where once you've got a report showing a place as a tip, then it's likely that you'll win. But say a judicial review is quite difficult. But legal aid should be available. The person in that scenario, if their whole issue is about their benefits getting stopped, the fact they're not in receipt of benefits doesn't mean they won't get legal aid, because if you've got no money coming in, you'll still get legal aid. You just got to explain to the legal aid agency that your benefit's been stopped, which won't be a barrier to you getting legal aid.
Cool. That's it, guys. There is a very quick question that was just coming in, which I can answer very quickly. It's a question about families and B&Bs. If you go on the YouTube channel, there is a video specifically about this, which I think is about how to claim compensation for being over that 6-week limit. To see, yeah, so there's a video called "Compensation for Families with Children or Pregnant Women Stuck in B&B Temporary Accommodation." So if you go to that, that will give you the answer to your question, and also tell you how you can complain about it and get compensation. So yeah, but other than that, guys, we're going to call it a night. So thanks for all the questions. See you next week on this channel. Will, are we about on your channel on Monday? You're on mute.
Sorry, yes, I'm planning to be about on Monday.
Yeah,
so
cool.
Hopefully see you all there.
So if you haven't subscribed to Will's channel already, if you just search for William Flack Law on YouTube, you'll get his channel, and subscribe to it. You'll get notification on Monday when we go live. So we'll see you then. Hopefully this has been useful tonight, guys. Thanks, as I say, thanks for all your input. Yeah, we'll see you soon. Take it easy.